Yes.
Let's talk about immunity.
Yes.
We know that within the House of Assembly, we have the senators, we have the MPs. In the House of Assembly, there is that privilege. And so they are afforded immunity for things that would have been said in the House. The legislation, the Act, gives the Chief Medical Officer and the other public officers referred therein immunity.
Right.
So is this the right interpretation of this section? That is section 61.
So section 61. First of all, Lisa, this is a false analogy, right? Because the scope and application of what you call parliamentary privilege is quite different from what section 61 provides in terms of our frontline workers, our public servants. But what we have here, 61, no action shall lie against the chief medical officer, public officer, member of the Royal St. Lucia Police Force in respect of an act done or omitted to be done in good faith. So let's give you, the parliamentary privilege really speaks to freedom of speech and the ability to conduct their affairs and what have you. This is a completely different scenario. And again, we are dealing with COVID-19. Let me give you an example. In terms of how this immunity would work. And it's not a blanket immunity. The statutory purpose of this piece of legislation is clear. And probably I should have read it earlier. If you just permit me 1 second, Lisa. The statutory purpose is the confines within which this act is supposed to operate. Okay. The statutory purpose means the preservation of the public health. That's in section 2 of the act. Means the preservation of the public health, maintenance of public order, and the securing and regulating of the pricing, supply, and distribution of food, fuel, light, power, and other necessaries. So these are the 4 corners of this act. So anyone who's performing a duty under this act, COVID-19 Act, it is necessary for them to have that level of immunity, which I will get to this a little later. But for our purposes, here, let's get into this example. You recall a case of there was a false positive test on this individual who had traveled
to St. Vincent.
St. Vincent. And this triggered a response by the team, the CMO and her team, in terms of how they dealt with the co-workers, of the quarantining of the co-workers, etc., etc. Someone could have determined that, or made a case that it was wrong of the CMO to have quarantined them. They were deprived of their liberty, etc., etc., etc. Now, that state of emergency, I'm talking about moving forward if a similar scenario occurs. What is the protection for those people? Are they now going to second guess themselves when they get that information? Are they required now to sit and run a test 3-4 times before they move? Because by that time we could talk about community spread of thousands. So we need to give them the protection to perform their duties and to do so quickly without having the prospect of litigation to follow them. In fact, they would be sued as servants of the state anyway. So really and truly, we would be facing a deluge of cases where persons will be claiming for compensation for acts done to them. And we need to have that sort of protection. This is not something which is going to be exercised in a capricious way. There are, as I just indicated, by the statutory purpose, the parameters within which they are supposed to work. Now, Lisa, this is not new to our St. Lucian context. Because the persons who have been advocating for the use of the Public Health Act ought to have realized that this is it's a replication of what obtains in there. They need to only look at I had a section here. Under the Public Health Act, right, Section 19 of the Public Health Act, it says, in fact, it says a bit more. Nothing done, directed, or authorized by the minister, CMO, or medical officer of health, or any person acting under the authority of any of them shall, if such thing was done, directed, or authorized in good faith for the purpose of executing any of the provisions of this act, subject such persons to any action, liability, claim, or demand whatsoever. Section 61 says, an action or other proceeding shall not lie against the CMO, public officer, a member of the Royal St. Lucia Police Force in respect of an act done or omitted to be done in good faith in the exercise or purported exercise of his or her functions under this act. And I used on good faith the example, if you tie it in, you got this
The false
test,
positive, yes.
the false,
yeah.
but you didn't know it was false. It ought to have been negative, but you got a positive test. Let's do the due diligence and pull these persons out, identify where the community spread is. You're acting in good faith. You need to protect those persons. We live in a very litigious society. We can't deny that. So we must give these persons a level of cover.
So then I think the public wants to know what protects them then, because, and I think too, what is the most contentious aspect of that lies with the Royal St. Lucia Police Force.
So here's my response. If you look to Section 3 of the Act, the same COVID Act, it says non-application. Where this act conflicts with the Public Health Act or other enactment, the exercise of a power conferred by this act is inconsistent with another act, this act shall not apply insofar as it conflicts with the power conferred under this act, shall not be exercised so as to limit or restrict the exercise of the Public Health Act or other enactment. That means criminal code remains intact. All the other pieces of legislation, it does not create a situation where these other pieces of legislation become secondary to it. That was not the case under the state of emergency. So as much as, so the issue of liability is specific. Liability speaks to civil matters. I think people need to make, or the citizenry, we need to appreciate the difference. You have criminal prosecutions and you have civil liability. So if you are acting in good faith under this act, if you have to go and detain someone for community spread, some persons may not be compliant, and you may have to use some level of justifiable force, etc. You have the cover under this act as it pertains to a lawsuit, but that does not prevent the individual from so acting as a virtual complainant, and you being charged criminally if it is found that you've met that threshold.
So if someone has a sort of, well, I say query, the word loosely, but certainly if they felt that they've been wronged by the police, that their rights have been trampled, you can go to the criminal code in order for you to address that.
Certainly.
And so this is not the end all and be all of that.
But it gives, once you have acted, once these functionaries have acted in good faith, that's a standard. This is why I like this real-time actual example of the case of St. Vincent. These persons acted in good faith. Persons it was mandated that they remain in quarantine for the 14 days, etc. So there are instances, and there is good justification for the immunity. Excuse me. And further, we have precedent for it. This is not new to our body of law. As I said, you need only look at the Public Health Act Those who are so minded could look at section 19, which speaks clearly on exemption from liability.